So, another important issue which arises in the context of impossibility and attempt is the case of the question of whether an impossible act could also qualify as an attempt. So, if an attempt is made to do something which was actually impossible to accomplish, then would it at the same time call for liability, or could the person be exonerated from the commission of that offence? So, the case of Queen versus Collins is something that needs to take our attention here. Here the pickpocket had put hands in a person's pocket for the for stealing money from his pocket, but the pocket was found to be empty. In the case of Queen versus Collins, no liability was fixed on the person. However, a subsequent case called the case of R versus Ring was another important scenario wherein in the same matrix of facts, a person, or in this case a woman, was held liable for the offence of pickpocketing now, or theft in this matter. So, in this situation the woman had put the hands her hands into someone's pocket, which was ultimately found to be empty, and according to Queen versus Collins case, as per the law laid down there, she should not have been made liable for or guilty for the offence of theft. However, the court held her responsible for the commission of theft. So, R versus Ring actually suggests a very different stand that was taken as in the case of against the case of Queen versus Collins. So, illustrations A and B of section 511 actually reiterate the point that was laid down in R versus Ring. Now, attempt to commit murder is something that needs to be distinguished here from regular forms of attempt. Now, the case of R versus Nidha is something that needs to be taken care of. So, a special provision has been made under section 307 of the Indian Penal Code, where attempted murders are penalized. So, the question in this case was whether a person should be held liable for the commission of the offence under section 511, or whether for attempting to commit murder liability should be incurred as per section 307 of the Indian Penal Code. So, here the court had opined that application of section 511 is a general principle and would not apply in cases where the specific provision has been made in relation to that offence or in relation to the inchoate offence of attempt. Since attempt to commit murder has already been covered under section 307 of the Indian Penal Code, therefore, it is not necessary to rope in provisions of 511 under this scenario, in this scenario. So, as to conclude, it is necessary for us to figure out certain important things that have come into operation. So, the first important thing here is that the 5th Law Commission report has made a very important recommendation in this relation. Now, as I told you in the earlier slides and in the earlier discussion that we had in the earlier part of the lecture, I mentioned that attempt has not been defined in the Indian Penal Code. It has been touched upon under section 511, the last section of the IPC, and of course, it is in this light that the 5th Law Commission report is very strong about the point that we should have emphasized on the law of attempt a bit more, and it is dissatisfied with the way in which attempt has been put in the IPC. Suddenly in 511 it starts showing up, whereas no mention has been made of it anywhere earlier. So, the 5th Law Commission has suggested an introduction by way of amendment of section 120C into the IPC, wherein a specific definition of attempt is provided. So, as we can see, attempt is an inchoate offence which is being dealt with by section 511 in a manner which needs more in-depth analysis, and at this juncture attempt has had to go through various phases of refinement. A lot of discussion has taken place about what amounts to preparation and at what stage it can qualify as attempt. So, at this stage it will be pertinent for us to sum up the discussion that we had throughout the lecture. So, the first important thing that we need to notice about attempt is that it is an inchoate offence or an incomplete offence, and it figures as this third stage in the commission of a crime. It is right after preparation and precedes the stage of commission in a crime. The most vital elements of attempt are intention to commit a crime, doing an act in furtherance of that intention which is more than preparatory, and failing to accomplish the crime. The Indian Penal Code has not defined attempt, but it has made a general punitive provision under section 511. Section 511 is applicable only where a special provision has not been made in the Indian Penal Code for attempt to commit an offence. It is necessary for us to distinguish attempt from preparation, and the following tests have largely been followed: the test of proximity, the test of locus ponipotentia, and the test of equivocality. Liability can be fixed for attempting to commit an act which is otherwise impossible. This also we have discussed in depth, and it is a very important point because it has gone through a lot of judicial analysis as to whether such situations can actually amount to a situation of attempt or not. So, we need to remember that attempt in its own way has to be understood in conjunction with the mens rea which is present. Since emphasis in fixing liability in the case of attempt is on the availability of mens rea and the actual quotient of mens rea existing, it is important for us to figure out whether the person had the mens rea or not, whether it resulted in the commission of a possible or an impossible act is not the crux of the matter. And in this situation, we would say that even if the act which one was associated with turned out to be impossible, if the intention to commit the offence was present, it would still qualify as an attempt. That's all. Thank you.